This is the Think Resolutions podcast. I'm your host, Howard Kline. In this podcast, I and my special guest, David, I am not qualified to be president because I cannot ever remember how to pronounce David's last name. Is it Reif or Reif?
You were right the second time. It's the long I.
Reif. Okay, so obviously at my almost ripe old age of 73, I obviously have cognitive decline.
Or I have
Or
I have a difficult name.
No, you've told me how to pronounce your name a number of times, and maybe I should just chalk it up to not remembering someone's name when you meet them, and I have to focus on it. In any event, David, I remember David.
There we
David
go.
is my son's name. We'll be discussing some recent Supreme Court decisions relating to arbitration, including the following topics: whether a trial court is required to stay a court action when it has denied a motion to compel, how and who decides if a matter should be arbitrated when there are two contracts that conflict on the topic of arbitration, and whether or not the contract should be arbitrated. We'll go into more detail. Obviously, that statement is a little broad. And to what extent, if at all, a corporate entity can claim that it is a transportation worker for the purpose of the exclusion from the Federal Arbitration Act. My special guest is David Reif, and after 4 decades of litigation, and excuse me for reading this, I didn't expect myself to memorize it. After 4 decades of litigation and dispute resolution over a wide range of disputes, David retired from active trial practice to concentrate on providing individual, commercial, and business arbitration, mediation, and neutral service. Based on the practice, he brings a broad experience in resolving as a litigator, a mediator, and arbitrator all types of disputes. Further information on David will be found on the description section of this podcast. My name is Howard Kline, and as I've previously indicated, I've been a California licensed attorney since 1973. During this time, I've also handled a broad range of real estate and general business matters, and including negotiations, contract drafting, and litigation. I've served as general counsel on 4 different occasions, in which case I've handled other matters, including employment and labor matters. I have not totally given up the practice of law, although I have minimized it considerably. If you are watching this video and like it, please give it a thumbs up if it's provided, and subscribe to my channel wherever it is, including LinkedIn. You can follow me on LinkedIn. So, David, welcome.
Thank you. It's a pleasure to be here.
Okay, so we chit-chatted a bit. Let's talk about the case of Smith versus Spizzirri. And why don't you give us a quick summary and the issues that you see that are resolved and not resolved by this case?
Sure. Smith took a conflict between the circuits. It is the classic conflicts case. And the issue that it took up is whether, when a court grants a motion to compel arbitration, can it dismiss the case or does it have to stay the case? Now, Federal Arbitration Act, which applied here and generally does, even if it's a New York Convention case, provides that the court shall stay on the condition that the party seeking arbitration keeps going forward and goes forward with the arbitration. A number of courts, and actually a minority rule, but about 4 of the circuits. And Justice Sotomayor lays them out in one of her footnotes, and I don't need to run through a list of circuit numbers here. But the majority had held that a stay means a stay. But the courts, a number of the other circuits said, look, a court has an inherent power to control its docket. And if arbitration is going to be held on all of the issues, so what we're assuming is it is a case where the court compels arbitration on all issues as to all parties, that the court has an inherent power to dismiss the case. The court took on Spizzirri in order to resolve that conflict and came out in a unanimous decision with no concurrences, nothing, saying that stay means stay. And so when a court compels arbitration, what it has to do is stay the pending case. So it looked at the FAA, and it did this on 3 bases. One, and I felt sorry for respondents in this case, because frankly, they didn't have a whole lot to stand on.
No.
They argued that the legal dictionary definition of stay at the time that the FAA was drafted simply said, stop the case. It meant no more than that. Justice Sotomayor says, no, everybody knows in legalese what a stay means. Secondly, they said what a stay means is stop the litigation. And if you dismiss the case, then you have stopped the litigation. Justice Sotomayor says no, that stay means stay. It doesn't mean throw it out. She then goes and looks at the language of the statute. And what she says is there's a statutory scheme that says the following. 1, you can take an appeal from the denial of a motion to compel arbitration, but not from the granting of a motion to compel arbitration. So what does that mean? If I allow the court to dismiss the case, then that constitutes a final judgment. So in effect, I can appeal from that dismissal, and people did it all the time. I can appeal from that dismissal and challenge the ruling to compel arbitration, which is exactly what the statute says you can't do. The statute says very specifically that compelling arbitration is not appealable. So the answer at this point is just clear in all the circuits. Court compels arbitration, court stays the case. Now that raises a bunch of interesting questions.
Before you get to that, isn't this a bit academic?
Oh, no. Here you are.
Let me add my 2 cents. So to me, stay, first of all, the court goes into an explanation saying that the statute says shall stay.
Mm-hmm.
So it worked on the definition of some elementary words in the English language, which is may. It's like we grew up in the city and say, may I do it? So what does may mean? May means, in this context, means the court has discretion. But that's not what the statute says. The statute says shall. This whole dissertation as to what may and shall mean. And to me, that's academic. It's first of all, shall probably is a word of art, and the word stay is a word of art from my perspective, meaning that's what it means. Now, I understand the discussion having to do with, well, stay, what does it mean? Does it mean stop the litigation? And then as the Ninth Circuit interpret that to mean saying, you're not doing litigation. We have the discretion to stop the litigation in a number of different ways, including keeping jurisdiction as a stay would, keeping it on the docket, but it, or the other option would be to dismiss it. And the Ninth Circuit apparently really didn't go into the kind of detail that the Supreme Court did in this particular case, where it then talks about what's the practical difference. And it does, the Supreme Court opinion does address that a bit. But to me, arguing about stay, I suppose the Supreme Court could have said, stay just means stop the litigation.
I think it has a big practical difference, though, particularly to lawyers in the 8th, 1st, 5th, and 9th Circuit, which were the circuits that said that you can dismiss it. Because let's look at what happens as the case moves forward. If the case is dismissed, then other parts of the Federal Arbitration Act, for example, that provide that if the parties cannot agree on an arbitrator, the court appoints the arbitrator. If the case is dismissed, that requires me to file, if I want the court to do that, requires me to file a whole new petition and go through all that. Stop and think about what happens after the case, particularly in light of Badgero, which said that you can't look through to figure out jurisdiction on a vacatur or confirmation. So cases stayed, I win, and my jurisdiction is based on looking through. So our fight is about Title VII. Our fight is about a patent. Assume that there is no federal diversity jurisdiction, that there's only federal question jurisdiction. Why? Because it's a federal statute. Under the FAA, I can bring an action in federal court, and the court can look through what the arbitration is about and say, this arbitration is about something that, but for the arbitration clause, would happen in federal court. What the Supreme Court has said, though, is you cannot do that for a motion to vacate or compel, or vacate or confirm. So let's assume I have that same case. I have no diversity of jurisdiction. I win my arbitration. If the case has been dismissed and not stayed, I cannot come back into federal court to confirm. If the case, I'd have to go to a state court to confirm. If the case has been stayed, then I can go to federal court to confirm, because why? The case is still there. So the court got jurisdiction in the first instance through look-through. It has jurisdiction. It still has the case. I now come in and move to confirm my award. I can't remember what the case is. There's a district court case floating around out there somewhere saying, no, you can't look through even if the case is already there. I think that is probably wrong. But that's the big practical difference. The court,
is that a Supreme Court case that you're referring to?
No, that's a district. Which
that'll be the next case.
That one, at some point, if the parties bother, it'll come up. It's still all the way down to district court. But that's the very practical result. I don't have to come back. Now,
there are some other potential issues. So the first one that struck me was, if you dismiss the matter, what happens to any statutes of limitation?
And that's a real problem because if I need to come back for some reason, the statute is run. So the statute's an issue, confirmation and vacature is an issue, general supervision of the arbitration is an issue. So from a practical point of view, it makes a lot more sense to have the case stayed, except that it makes it more difficult. I can't then sit and bring a new case and try to get some discovery. That's the one issue, and that's where counsel are really going to have to be proactive. Because if the case is going to get stayed and I want some discovery, I need to try to get that done before the court grants the motion to compel arbitration. Otherwise, I am probably stuck with arbitration, with the limited discovery in arbitration. So how do I do that? I think number one is hope that I have the right judge who is not going to move quickly, who is going to let me get some stuff filed before the Rule 26 conference. Now, discovery doesn't start until the Rule 26 conference, but at least I get it filed. Number two, 21 days after the complaint is served, I can get under Rule 34 without getting technical, but I can file a request to produce documents, get that in so that when I go into the Rule 34 conference, I can say to the judge, hey, I understand that you're going to stay this, but can you hold off on the motion to compel long enough for me to get this discovery? The right judge may say yes. You and I, and a lot of the listeners have tried cases long enough to know that if you get to the judge's heart before you get to her head, you can get her to do a whole lot of things. The other is what the court has ordered is a stay. But trial courts, under certain circumstances, can lift a stay for limited purposes, assuming the standards for lifting stays. So let me give you a hypothetical. Court has compelled arbitration. Arbitration hasn't happened yet, and we're still in the process of picking arbitrators, all of which can take a couple months. The day after the order compelling arbitration comes down, I learn that a crucial witness to my case is about to leave for Saudi Arabia or Germany or Japan or wherever, and is not prepared to come back to be deposed, is not willing to accept any service, and is in fact a hostile third-party witness whom I'm going to have to subpoena. Arbitrators can't issue a subpoena. Supreme Court has said that 1782 would not apply, discovery for use in a foreign arbitration, because let's assume the arbitration is going to happen here. So what do I do? Seems to me in that circumstance, a lot of judges are going to say, I will lift the stay for the limited purpose of allowing you to take this deposition. You still have the fight under the FAA to stay. What does stay mean? Shall stay. Does it mean complete hands off, or does it mean somewhat? I think Justice Sotomayor, in her opinion, talked about the trial court. It remains on the trial court's docket. The trial court can do things to deal with the administrative burden. I think there's a wink and a nod there that the court can do other very limited things during that stay. But
Well,
you're a trial lawyer. You got to take your shot.
yeah, there are a couple of issues that we won't go into detail, but according to the FAA, your ability to subpoena and get discovery from third parties is severely limited. So, as an arbitrator, we can issue subpoenas, but it can only be for a hearing.
Right.
And discovery is not considered a hearing.
And the other is that the FAA says that the district court can enforce an arbitrator's subpoena. But what I posited is that you don't even have an arbitrator yet. The other way around it, maybe. Let's not forget the common law that we learned way back when we were in law school.
It was when the books were in stone tablets.
Well, not quite, but close. But one of the common law writs, and almost all states have it, either by common law or by statute, is something called a bill of discovery, which provides that if you need discovery prior to an action, you can file a bill of discovery, and a court in exceptional circumstances can grant it. So one of the options that's open to the party that wants to do discovery, generally the plaintiff, because they've got the burden, who wants to do discovery, is if you've got a witness that's in Kansas, go to Kansas State Court and try to get a bill of discovery. I think that one of the things that is terrific about being a trial lawyer is that you are required to be imaginative. And it's the nature of the beast. And so trial lawyers do not take well to it cannot be done. And so I think those are three potential ways of getting some discovery during the pendency of the stay.
It's interesting that you say that about lawyers being imaginative, because I think that the general belief in the public is that we are not imaginative. But I sure have spent a lot of time thinking of things that other people haven't thought of.
Sure.
I've had opposing counsel say, "You're crazy." And I might have been. But I can recall some instances where I'm going, just because you didn't think of it? And I would say I have prepared myself to go into court thinking about a zillion things that could happen, and it was not uncommon that none of them ever happened from the other side. They just didn't think of it.
That's right.
But I was prepared for it.
That's what makes practicing trial law fun.
Yeah. It's any kind of, whether it's trial law or doing transactional work. So let's move on to, and I think that you've addressed everything here. Okay. Coinbase versus Susky.
Sure.
Why don't you tell us what the holding in that case is? And you and I have discussed Coinbase on a number of occasions.
Sure. Some background. Coinbase, this is basically out of the same dispute that the Supreme Court had last year in Coinbase Bilski. Coinbase is a cryptocurrency exchange. When you sign up, you sign an arbitration agreement, or when Bilski and others in the class signed up, they signed an arbitration agreement that had an arbitration clause that provided that disputes between the parties would go to arbitration under a delegation clause where the arbitrator, what's now a pretty standard clause, where the arbitrator would decide arbitrability. Coinbase then ran a contest dealing with Doge, D-O-G-E coin. I don't even know if
Dogecoins.
I don't know if Dogecoins are even still around, but they were one of the cryptocurrencies. And this contest had a set of official rules. When you went into the contest, you agreed to abide by the official rules. The official rules did not have an arbitration clause. So the question then that ultimately reached the Ninth Circuit was, is this dispute arbitrable? And if so, who decides whether it's arbitrable? Ninth Circuit looked at California law and said that the second agreement did not provide arbitration. Second agreement is the one that applies, and therefore we're not going to order arbitration. Case came up, and in a unanimous opinion, but with a concurrence by Justice Gorsuch, the court held that no, what you have to do, and the Ninth Circuit said the arbitrator would otherwise decide arbitrability. Justice, the U.S. Supreme Court says, no, you've confused two things. And this is Justice Jackson, who wrote this opinion, talks about three levels of decisions in an arbitration. She says, one, you have to decide the merits. That's one level. Two, you have to decide arbitrability. That's a second level. Three, you have to decide who decides arbitrability. That's a third level. She said this case raises a fourth level, which is where you have two agreements, which agreement controls. What they did is they said here, the Court of Appeals, Ninth Circuit, decided the case basically on the wrong theory. And what has to do is it has to go back to the district court to decide, did the parties agree to arbitrate? And inherently, which of those two, what was that agreement? That's basically pretty basic arbitration law. While you can delegate other threshold questions, gateway questions, like arbitrability, the scope of the clause, those kinds of issues, unconscionability, those can be delegated. You cannot delegate the formation of the contract, which makes sense. Going back to contract law, I had my contract professor used to say, ex nihilo nihil fit. And no, I did not go back so far that I was in law school taking Latin. But that means out of nothing. And so what it basically means in this context is that if the parties have not entered an agreement, then you can't look to that agreement to decide if there's a delegation. Justice Gorsuch concurred really just to make it clear that what the only thing that was being decided was no questions regarding delegability, no questions regarding any of those issues. It's just which of these two contracts come. This is one of those cases that, frankly, when I read the petitions and those things, all of which, by the way, and I'll put in a plug, go to SCOTUS blog. If you go to scotusblog.com, they have all that stuff. But when I read it, I kept saying to myself, why did they even take this case? It struck me that this should be a dig. Decision to grant cert, decision improvidently granted. because it really struck me as being a contract issue, just a question of California law. Does the second case supersede the first? I think what the court wanted to do was just to, in light of all the case law out there on delegation, I think they just were looking for an excuse to reconfirm that formation of an agreement has to be resolved first and cannot be delegated. And that's why I think they took this case.
Yeah, so the bottom line is the trial court really needs to make that determination as to which contract prevails for the purposes of arbitration.
That's exactly right. Which of those two contracts did the parties intend to govern the question of arbitration? Now, I don't want to say it's a silly question, because it's not. It's a crucial question. But you can't tell me that a bunch of people entering a Doge coin contest had any concept as to which of two agreements they wanted to execute. They probably didn't. So an awful lot of this is going to come down to California contract law as to what's the effect of a second contract on the first. Is it an novation? Does it simply fill in the blanks? The crucial thing coming out of this case, I think, is a lesson for contract drafters. When you're drafting an arbitration clause, be sure that you have all the relevant contracts in front of you so that you can make a decision as to how you combine the two. That's lesson number one. Factually, I don't know whether these contracts were both drafted by Coinbase, whether Coinbase drafted one, Doge drafted the other. The lesson there is that if you're general counsel, be sure either you or somebody else is acting as quarterback and is keeping an eye on all of the moving parts. I go to the hospital, I have a neurologist who looks at one thing, I have a orthopedist who looks at something else, and I've got an otolaryngologist who looks at the third. Each of them is looking at their system. What I also have is a hospitalist, used to be called a physiatrist. I have a hospitalist who's making sure that all of those three are in sync. General counsel has got to act as a hospitalist where you're dealing with multiple agreements.
Absolutely. And I will tell you, as a former general counsel, this is not an easy thing to handle. I can really see how this could happen so very easily. Someone probably hired outside counsel to put together the terms of the contest. Nobody bothered to look at it, although that attorney arguably should have asked the question, are there any other contracts in this case? But boy, this is an accident waiting to happen.
Sure.
And that's how I look at it. It scares me because I could see how I might have been able to mess this up. But then again, being familiar with California contract law, pretty common that the second contract would prevail unless it caused some sort of conflict in the actual language. As a matter of fact, one might even argue that usually prior to trial, a lot of our argument is whether or not we can get certain evidence before the court. And on contract law, it's always, is the contract clear on its face, or is there some sort of ambiguity where I can get all of this other evidence in that I want to get in. And that's a lot of the battle. And in this case, I could see that happening too.
Yeah. And in the Doge they use contest rules. What it really just talked about, it was just a choice of forum. But it said all disputes shall be resolved in California, in state and federal court in California. And it had the language sole jurisdiction. So this is probably I think it's going to be a pretty tough case at this point to get these to arbitration. It'll be interesting. Coinbase has very good counsel, as do the plaintiffs. So it's going to be interesting to follow this as it goes along, because you're going to see really good lawyers dealing with an issue.
You and I also had a conversation in Atlanta at the ABA Annual Arbitration Institute, because this was presented by two very good attorneys. And where you and I got into it was these attorneys, their statement, and I'm sorry I forgot my name. If I could forget how to pronounce your name, I'm authorized to forget their name. They were very good, but one of the comments they said was that the language, the arbitration provision, the language was very broad. And I looked at it and said, well, actually, it could have been much broader. And I think this goes to Justice Gorsuch's concurrence, is that if the original contract, the earlier contract, which was the user agreement, where the arbitration agreement was in, if that was so broad to say that all future agreements between the parties is subject to arbitration, that would have, I think, perhaps had resolved the issue of the conflict. But that causes all kinds of other issues, such as what if the parties really want to, at a later time, not arbitrate? How do you go back and change that? How do you reach back and say, before we agreed, and notwithstanding any future agreement, everything's got to be arbitrated? Now is a future agreement, and we don't want to do it. So how do we change?
Yeah, that one doesn't trouble me, because parties can always waive their right to arbitrate. They do that all the time, either intentionally or unintentionally. I think that what makes this case unusual is the really strong language in the second agreement, which is sole jurisdiction. I agree with you that there are circumstances, but I think even you could have that as broad as you wanted, and you've still got this subsequent agreement that says sole jurisdiction. If that language is not in there, then I would agree with you.
Okay, let's move on. Can they come back in the rules? You raised this issue in Rule 60, which is a 1-year statute to go back and on a case that had previously dismissed.
Well, yeah, the interesting question, and this rolls back to Spizzirri. If I have a case that was dismissed, assume that Spizzirri came down sometime within about the last month. Let's say that in January, I'm in one of the circuits that says that you can dismiss. The case is dismissed. So and it should not have been dismissed. Supreme Court says you can't dismiss it. What are my options? Because clearly for all the reasons we talked about, I want to try to get back into court, or assume I want to get back into court, because I think I would. Rule 60 says that within 1 year, Federal Rule 60 says that within 1 year you can move to basically reopen the judgment. So I think what we're going to see district courts flooded with, unless I'm really off base on this, is cases which were dismissed along with along with the compelling of arbitration. You're going to see people moving under Rule 60 to reopen that judgment and to substitute a stay for the dismissal. As the case
Now
is,
that's with if that's within 1 year of the date that the dismissal was entered, correct?
if it's within 1 year of the dismissal,
So I'm not an expert.
or
on
even if
this.
it's outside, there are certain circumstances under which you can reopen a dismissal even later. But let's take the easy one. Let's take the 1 year. There's a bunch of case law out there in other issues on both sides saying the question of whether a change in the law is a basis for a reopening under Rule 60. We're going to see, because those motions there's going to be a bundle of those motions.
Sure. Okay, let's move on to follow up with Bissonette
Sure. Two quick things.
versus Flour, or you are referred to as the Wonder Bread case.
Sure.
And this other case is Estanislao Enterprises versus FedEx Ground Corporation, which I see that they are related. So why don't you give us a brief reminder of Bissonette, which came down 24.
No, Bissonette was earlier this year.
Yeah, it was in 2024.
Oh, yes, 24, yes.
Yeah. And you and I have already discussed that online, but why don't you give us a brief update on Bissonette or a reminder?
Sure.
And then I'll talk about the difficulty that I mentioned in our last discussion with Bissonette, and I think the Estanislao case does relate to the problems that I...
It absolutely does. Real quickly, Bissonette, Federal Arbitration Act exempts workers in interstate commerce. And the question has always been, there's been a split in the circuits, and there's been all kinds of decisions, even at the Supreme Court level on this one, Southwest Airlines. So the question is, had been before Bissonette, do you look to the industry in which a person works, or do you look to the job the person does? And Bissonette was, as you said, Wonder Bread and cupcakes and things like that, was the person who drove trucks, had basically a franchise, is what he alleged, drove trucks and delivered to grocery stores, bodegas, convenience stores. And the question was, filed a claim. LaPage, the employer, sought to compel arbitration. He says the FAA doesn't do that because I am a worker in interstate transport. Supreme Court agreed. Supreme Court said, what we do is we look to your job. And he spent most of his time driving a truck, delivering stuff that was clearly interstate merchandise. And they said, yes, you're not covered by the FAA. So there have been two decisions that have come down since then, both of which I think are interesting. One is the...
Before you get to that, let me raise the problem that I had with the Bissonette.
Sure.
So it's important to understand that Wonder Bread or Flower Foods or whatever it was called, the responding party, they had a contract with a corporation, not the individual
Right.
driver. And however, there's all kinds of arguments whether or not you can go to the individuals and basically ignore the corporate existence. But basically, Wonder Bread required these drivers to form a corporation, and then Wonder Bread had contracts with those corporations. And I raised the question going, well, wait a second. Nobody's resolved the issue of whether or not these individual drivers even have standing to argue that they should be excluded because they are workers, but they're not who Wonder Bread contracted. And that was the subject of my problem with the Bissonette case. And maybe as a trial lawyer, I think in terms of I've got to establish first that my client has got standing. They even raise this. So now go on with these other cases because they do touch on that.
Sure.
They don't resolve it, but they touch on it.
Estanislao is an action against FedEx Ground and just came down Western District of Pennsylvania, July 5th. Just came down a couple of days ago. And that's a case in which Estanislao Enterprises brought an action against FedEx Ground. FedEx Ground says, hey, look, interstate, the FAA exception applies, and you've got to arbitrate this thing. And the court holds no, Estanislao is a corporation and therefore is not itself a worker in interstate commerce. It's a company. And so they hold that no, the exception does not apply. And so we can compel arbitration. FedEx wanted to arbitrate. Stanislao says no. Court says yes.
Yeah, now where I distinguish Bissonette from Estanislao is that Estanislao sued in the name of the corporation, where Bissonette, the individual, sued. So Estanislao seems very clear that they're not workers. And that court made it very clear. If it goes up to the Supreme Court, who knows what is going to happen, but I suspect that it may end just where it is, or if it goes up, the Supreme Court will either confirm or not even take the matter on appeal.
Yeah, I think that one's right.
Yeah, and now you had mentioned that there was another
case. There's one interesting case, and I tried to find the citation for it before I got on, and I couldn't. But the question is, okay, there are really two questions. One, if the FAA does not apply, can I still compel arbitration under state law? So the agreement says the FAA, we're going to go with the FAA. FAA doesn't apply. Is it the exclusive remedy under my agreement? Or can I go to the state? This district court case, and I tried to find it, and frankly, anybody who's involved with this question ought to spend the time to find it because it can be a really valuable case. Said, yes, you can look to state law, but since you said it would be arbitrated under the FAA, we say that the state is then going to look to all of the FAA, including the exceptions, and therefore although you would be able to arbitrate under state law otherwise, because you've invoked the FAA, we're going to do a great big circle and we're going to apply the exception under the FAA. No, you cannot compel arbitration.
If you are drafting the arbitration provision, how would you resolve? I suppose it depends upon which side of the fence you're on.
If I were
If you're representing the company that wants to have arbitration,
I think if I'm on either side, I'm not going to reference the FAA. If I'm dealing with interstate commerce, the FAA is self-triggering. So why take a chance? Certainly, in any case, but certainly in a case where I have somebody who might arguably be under one of the exemptions of Section 1 of the FAA, I am not going to reference the FAA. I'm going to let it be self-executing.
now that's interesting because I think I have two arbitrations where the arbitration provision references the FAA.
There was a time. There was probably a time. There was certainly a time to do it. If you're dealing with somebody who's a potentially an employee, a worker in interstate commerce, you don't want to do it now.
This was not really, can't go into a lot of detail, but for the moment, assuming that it's a consumer case, that it is nationwide. I think someone just said we want to be covered since it's nationwide and one company is involved in interstate commerce, then let's mention the FAA.
If I was just
But as you said, the FAA would be automatically triggered.
yeah, if I were dealing with a consumer, I might reference the FAA just so that I don't have some state court decide to go off the ranch.
And we'll have another discussion because I'm in the midst of preparing drafting language for arbitration provisions, focusing on whether or not and to what extent the parties might want to have some discovery. And so when it comes to commercial leases, I'm pretty competent to advise on what the language should be, but I might be a little reluctant I would have to pay attention to what kind of and how much discovery I could do. Paying attention to the organization that the parties would have chosen. So looking at the discovery with the American Arbitration Association, if it's highly unlikely that the amount in dispute is going to be more than $100,000, you're going to be severely limited on your discovery, yet you may not want to be.
Yeah.
That
drafting really depends on which side of the V you think you're going to be sitting on.
Absolutely, because in a commercial lease, the landlord is not obligated to pay for the fee. It's highly unusual to see that. Frankly, it's highly unusual to see an arbitration provision in a commercial lease, notwithstanding my recommendations to the contrary. But if everybody listened to me, I would have never made money as an attorney.
Often, as a trial lawyer, I often felt like the guy in the circus parade behind the elephant with the broom and the shovel.
That's a good description. People call you up and they go, here's the issue. And you're sitting there going, I understand. Yet in the back of your head, you're going, seriously. Then again, as an attorney who sometimes doesn't follow my own advice, I have on too many occasions go, Howard, what are you thinking? In any event, thank you very much.
Thank
As
you.
usual, David Reif.
You got it.
I've had my moment. Maybe I can run for president. Thank you very much. We should have this out, by the end of the weekend, if not sooner. What's today? Thursday? By the end of the weekend, I'll work on this. I don't think that there'll be a lot of editing required. Plus, this will be not only a video podcast, this will be a audio podcast. So by the end of the weekend, I will have all of that reason. It's Think Resolutions. I'm Howard Kline. My special guest is David Reif. And that's a wrap.
It's always a pleasure. Thanks, Howard.
You bet.